How are mercy killings handled under the current criminal law? Hello, I'm Simran Katani, and today I'll be discussing mercy killings in the law. So under the current law, there is no full defence or partial defence for mercy killing. Mercy killings are typically defined as killings on compassionate grounds in order to relieve the victim's suffering. Currently, a defendant who committed a mercy killing would be convicted of murder and would receive a life sentence with a minimum term determined by reference to Schedule 1 of the Criminal Justice Act 2003. Paragraph 10 of this schedule contains aggravating factors, such as where the defendant pursued a significant degree of planning or premeditation, where the victim is particularly vulnerable, and where the defendant had abused a position of trust. Paragraph 11 of the schedule gives mitigating factors, which include the fact that the offender suffered from any mental disorder or mental disability, lowered his degree of culpability, the fact that the offender was provoked, and a belief by the offender that the murder was an act of mercy. These aggravating and mitigating factors do not affect the labelling of the crime as a murder, but they can increase or reduce the sentence imposed on the defendant. So an example of where these factors have been considered in sentencing is 2007 Inglis case. In this case, the victim was in a vegetative state. His mother compassionately tried to kill him, but she was charged with attempted murder and was released on bail under the condition that she did not visit him. A year later, she killed him again by injecting heroin. She was charged with attempted murder and did not rely on the partial defence of diminished responsibility, meaning she was convicted of murder with a mandatory life sentence. The minimum term set was overturned in the Court of Appeal after considering mitigating factors such as the fact that the offender believed the murder was an act of mercy, and the fact the offender was provoked by prolonged stress, although not to the extent that the defence of provocation could be used. Although some aggravating factors, such as the fact that there was a significant degree of planning or premeditation and the victim is particularly vulnerable because of a disability, would have increased the sentence in a regular murder case, the court held that these factors should not be taken to aggravate a murder committed by a mercy killing. Otherwise, the mitigating factor of mercy killing itself would have no effect. Thus, the defendant was still guilty of murder, but her mandatory life sentence with a minimum term of 15 years was mitigated to 5 years. This case shows that mercy killing cases are generally labelled as murder, although the minimum term of the mandatory life sentence can be mitigated. The same stance was taken in the case of Douglas, where a mercy killer was convicted of murder and given a mandatory life sentence with a mitigated minimum term. This reiterates Inglis, where it was stated that the law of murder does not distinguish between murder committed for malevolent reasons and murder motivated by familial love, which followed the unreported judgment in the case of Lund, where the judge directed the jury to find the defendant guilty of murder for smothering his dying wife with a pillow after she had taken 80 paracetamol to die but had not been successful. In these cases, mercy killing is not distinct from murder in terms of labelling. However, an exception was seen in the case of Webb. The defendant in this case was acquitted of murdering his wife, but was convicted of manslaughter because he relied on the partial defence of diminished responsibility. So in this case, he smothered his wife after she tried to commit suicide, and she had made it clear that she had wanted to die. He himself had been suffering from adjustment disorder, which affected his social functioning, satisfying the requirements of diminished responsibility. There is little clarity as to why the defendant, Webb, was convicted with a lesser crime, as he could rely on the defence of diminished responsibility, whereas in the case of Douglas, the defendant was unable to use this defence. So it's not always clear when the mercy killer can use this partial defence of diminished responsibility for a mercy killing. So this defence, diminished responsibility, was originally set out by Section 2.1 of the 1957 Homicide Act, and it was a partial defence to murder where the defendant killed the victim while suffering from an abnormality of mind substantially impairing his mental responsibility. This made it easier for mercy killing cases to be covered by the defence, as it was a very broad defence. It was very broad, and as stated in the case R. Byrne, it is wide enough to cover the mind's activities in all its aspects, the ability to form a rational judgment, the ability to exercise willpower to control physical acts. However, In the 2009 Coroners and Justice Act, this section was narrowed to only apply where the defendant suffered an abnormality of mental functioning arising from either a recognised medical condition substantially impairing their ability to understand the nature of their conduct, form a rational judgment, and exercise self-control. This may exclude diminished responsibilities and mercy killings where the offender acts out of compassion rather than a medical condition. The requirement for a medical condition meant that in cases like Douglas, the defendant who was not suffering from a recognised condition could not use the partial defence. As juries are choosing the outcome where they perceive the defendant was not guilty out of sympathy, they can allow the defence of diminished responsibility even where there is not a clear medical condition. The case of Brown indicates that adjustment disorders and stressful life events could satisfy the recognised medical condition requirement, explaining the outcome of the case Webb. But again, this contributes to the arbitrariness of this area of law. Therefore, the current criminal law views mercy killing cases as murder, with the only distinction being a mitigation for sentencing. However, the cases have shown that public, jury and judges view mercy killing as less serious than other homicide cases. Therefore, there has been some level of stretching of the partial defence of diminished responsibility. It is argued that a partial defence of compassionate killing would be beneficial, as it ensures that there's fair labelling for those that commit these types of killings and allows defendants to have a lower conviction of manslaughter rather than murder. This ensures that there is enough deterrent from killing out of compassion, as it should be a partial defence rather than full. But this also respects the victim's autonomy and makes a partial defence more balanced in regard to the focus on both the defendant and the victim. Thank you for listening today.